building up this market in 2027. We know this affects numbers, but what does that mean for Lockheed?
Well, what it means is we will have to be able to invest even more because we'll get more and more of these long-term agreements. It's unprecedented, and I think it's the first major system in decades. We have a commercial agreement between the U.S. government and a major defense contractor like Lockheed Martin. That 7-year agreement, both of them all ability to invest quickly right up front, know that the demand was going to be there, the commitment by the government to have that demand, and act more like a commercial business, and we can access our own cash flow more effectively. We can use out to the capital markets if we need to with a competitive offer and get this job done.
That is wonderful, too. Let me ask you about the potential for a shutdown. A lot of worry that if we in fact see a government shutdown, that's going to throw wrench into all of these plans.
Right now, definitely slowing us down, so we're hopeful that there is no government shutdown coming this week or anytime soon. We want to be able to pay them. We want to be able to have them keep producing these items that we really need in the country. Government shutdown, continuing resolutions, late budgets, none of those are helpful. So if we can avoid a government shutdown, it would be very important for our demand.
And of course, we're walking this balance of ensuring that you are stepping up into the production in the productions in the U.S., but then also talking to shareholders and ensuring that shareholders understand the balance here. So what do you tell shareholders in that regard?
Well, and one thing is the agreement that we have on Patriot, and now even this morning, brand new, the THAAD system. What we've done for our shareholders is, first of all, we've got long-term commitments on these major programs for our company like we've never had before. That gives them a lot of confidence in the stability of our cash flows and our business going forward. So that's a huge plus. We're working on a number of other major programs, which I can't talk about quite yet today, but there should be more good news coming out on those long-duration contracts. Secondly, in those contracts and those agreements that we've struck so far with the department, we have the normal protections. If there's a change in the government strategy, if the budget changes, if the program is reduced or even canceled, we have make-whole provisions in these agreements that will compensate and protect our shareholders from any change in government policy down the road. And third, and really important, is there are escalation clauses in these long-term agreements, meaning we want to take inflation risk for our investors for the next 7 years. There will be an index-driven inflation escalator that go along with these contracts. And fourth, and also very important, the U.S. government realizes that cash flow is important to investors, and we have to maintain a reasonable amount of cash flow for them. As a result, they've agreed to work with us on payment schedules and other cash management opportunities between government and industry to help us make sure that investors are cared for along the way of that contract. All these benefits and protections are in these agreements. It took a little while to negotiate, I'll tell you, but we really landed in a great place. Deputy Secretary Feinberg has been personally involved in this, as have I and others, and we think we've got the right formula now to really change the defense industry for the better in a very big way over the next few years.
And Jim, this is so exciting. A lot of positive things you just mentioned, and I know that Lockheed Martin is poised to participate in a big way in the president's plans for the Golden Dome. So I want to take a short break and then come back with you to talk a little about the Golden Dome.
Grass can relax. The FBI has really confiscated the 17 boxes of rest. Pallet 7, 23 boxes, 44 boxes, 23 more over here, 28 boxes over here. These are all
So on January 28th, the United States obtained a search warrant under seal, and that is to address all Salinas. Oh, it is this district. Wow, unsealed in Fulton County, Georgia. You got Florida coming down out of the northern district of Georgia, the Atlanta division. And this is the battle of Rob L. Pitts, this guy right here, who was in Fulton County explaining that arrests are coming after the FBI went and got 2020 election records, of which we know are riddled with fraud and other problems. If you missed this clip of this guy, he is the Fulton County chairman, the guy who runs the county board, and here's what he said some time ago about this race.
See the call last week before the raid that they were going to give arrests in Georgia. Secretary of State, Deputy State, with the other. That did not happen on Monday. It did not happen the lower poll. The FBI so that we were releasing the real facts. That is so that we were she was in fact there. So that some percentage of the so that's what so and that is after we get ready so probably see another actually so you guys can the FBI obviously so arrests
that you want those documents back and cannot allow you to have evidence they can be used in our prosecution. The judge over the weekend on Saturday said, "I've been done. Now the case has been unsealed." Saying a couple things happened. One, Rob Pitts, the guy who and the Fulton County Board of Registration, they sued the United States of America. The FBI and the documents say one of the items in the search warrant. Thus far, the bunch of stuff. Emergency motion to go file back. Motion to unseal the affidavit, which the judge said we should get tomorrow. Another emergency motion to revoke rules, and another emergency motion to determine whether we can file these things under seal. The judge said, all right, well, all of this is currently sealed, and although we filed this under seal, both parties, so the Fulton County people and the DOJ are okay with unsealing all of this. The DOJ, the FBI, they say, hey, we've already gotten files. We don't need to keep this under seal anymore. And so, sure, look inside. They don't oppose also responded, in this case, the FBI and the DOJ, they don't oppose unsealing the search warrant affidavit either. And so, the judge says, given the importance of the public's access to this matter, the clerk is directed to unseal this case. We now are looking at it. The clerk is further directed to unseal the motions from Fannie, Land, and Fulton. And as to the search warrant affidavit, the DOJ has until the close of business tomorrow to unseal the affidavit, which is the justification for the raid in the first place and the search. And so we're going to see that probably tomorrow. But of course, we had a lot of questions about what's going on in Fulton County. We've got all these emergency motions filed. And I wanted to just fast forward a little bit to show you this receipt. This was attached in one of their exhibits. Fulton County submitted their lawsuit. They said, give us those files back. And they sent in a picture of this as another exhibit. Exhibit 2, as you can see here. And it shows us the pallets full of ballots. All the things that we've got now in FBI possession. And it's a lot of stuff. And you can see 28 boxes here in one pallet. Over here, we're going to be battling over the boxes because they're saying the box numbers don't match up. We're missing some boxes. Where did the missing boxes go? But here, multiple pallets. All right, boom. Pallet 7, 23 boxes, 44 boxes, 23 more over here, 28 boxes over here. These are all of the election records that we have been trying to get our hands on for years now. They all have been shifted into DOJ jurisdiction, and we're looking forward to seeing what they discover for us. So here is what they sent. Now, the reason this is fun is because they'll walk us through what happened when the FBI was there. From their perspective, we'll be able to see the recitation of the facts here. But this is the emergency motion from Rob Pitts and the freaked out Fulton County people saying, on January 28th, a glorious day indeed, the United States government obtained a search warrant, and it was a good search warrant, too. Can't wait to read it. The United States executed that warrant later that day, and they seized 656 boxes, maybe containing the original versions of the 2020 election materials from Fulton County. And they're unhappy about this. So now we're suing. We want you to return all of the original materials, or at least give us copies of what you seized. That is from just the initial filing, and they attached a big fat memo on the other end of it. Here is where that starts. They say, all right, the Fulton County Chair of the Board of Commissioners and others say, you still have these documents from us. And courts look at 4 factors to see whether this court can exercise, and this is a little strange to the court, there's an active criminal investigation
litigation going on right now. And so they're suing in a different court to say, you use your power to go tell that other judge. Another judge in Missouri granted a search warrant and said, yeah, go find it. There's probable cause here. Go get all the evidence. Good luck. So now they're going back to Georgia, right, in a different court. The search warrant is from a different state, and they're saying, Judge, you in Georgia need to reach over there in Missouri and say that judge's search warrant is basically invalid. Order the FBI, the DOJ to give us background materials. Now, if these are election records, which is pretty important, if these were illegal alien records, like you could almost guarantee that would happen. But because these are election records, not illegal aliens, we're not really sure what the ship is going to do, but we'll see. So here they say, look, there's a bunch of reasons we can get it. They're callously disregarding the Fourth Amendment. No, they're not. They went and got a search warrant that was signed off on by a federal judge. We did Fourth Amendment analysis and granted a search warrant. Idiots. They say this seizure is callous disregard for our efforts. There's a 5-year statute of limitations, and this seizure is disregarding our Fourth Amendment rights. No, the judge signed off on it. And in some, they say misconduct deprived us in Fannyland of our constitutional rights. And what's going to happen if these records don't get returned? We're going to die. So accordingly, this court should consider on an expedited basis to go and validate the other judge and make the judge give the records back. Here's the facts, and this is where it gets a little bit more fun. So on January 28th, the United States obtained a search warrant under seal from Magistrate Judge Salinas. Oh, it is in this district. Wow. So it is in Georgia. See, our rumors, we don't know. We haven't seen the search warrant yet, so we're all coming into this for the first time. The search warrant actually came in this district from a magistrate judge. Wow. And Exhibit 1, all of it's redacted, and that is still redacted. Here's what it looks like, all right? So you can't see it exactly. What is that? We don't know. Now, later that day, FBI agents executed the search warrant. Now, the seized materials are original records from the 2020 election in Fulton County that were held under seal by the clerk of the court in Georgia. And under Georgia law, those records are supposed to be safeguarded by us, and they have everything. They're in sealed containers. They've got voided ballots. They've got stubs. They've got numbered lists. They've got voters' tally sheets, voter machine proof, absentee ballots, related documentation, and more. And so the FBI took the records from our custody, and Georgia law says we have to have those documents. So as set out in detail in our simultaneously filed motion to unseal the affidavit and the search warrant, the warrant was based on debunked claims of voter fraud in Georgia. Not that debunked. Apparently the judge thought that there was something pretty credible there. And Fulton County. These allegations of fraud have been exhaustively reviewed. And so they explain now 3 related legal proceedings have been pushing forward here. We've covered, I think, all of them. In September of 2024, a member of the Fulton County BRE, Board of Registration and Elections, I think, sued Fulton in Superior Court seeking a declaration that her duty to certify elections was discretionary and that she needs access to the materials. Then in November, Fulton County filed a petition in Superior Court to quash 2 subpoenas. November 24, Fulton County filed a petition to quash those subpoenas, and the battle has been brewing over there. Robert McBurney, locally, denying the quashal, and the battle continues. Then the DOJ came in. Trump administration sought the same 2020 Fulton County materials through demand letters and federal litigation. We recall, back in October last year, the DOJ sent a letter over to the Board of Elections demanding inspection of all the records in your possession, and we also sent you a subpoena. Okay, civilly, we've been asking for these records. Can you please cooperate with us? Federal law says under the NDRA, under HAVA, if you have an obligation when the AG requests these things to give them to us, will you do that? Answer no. The board responded saying, sorry, these are under seal, and we can't give these to you absent a court order. So then in November last year, the DOJ wrote to the clerk. They said, listen, clerk, you have to give us these records. Then on December 11th, they sued. We absolutely covered that case. Harmony Dillon is launching lawsuits in a number of states because they're refusing to deliver their election records. Federal law says they have to. They refuse to because they know that they have lots of rigging going on. The DOJ sued Raffensperger, the Secretary of State, and wanted everything. I want birth dates, addresses, driver's license numbers, and all the things. Then on January 28th, while both the Allen case in state court and Alexander case were also pending, and while the state court had already authorized some of this, DOJ, all this stuff is pending, the DOJ says enough already. Okay, there are records, we're coming forward. The DOJ got the warrant, physically removed the original sealed records from the clerk's lawful custody, not that lawful. So they're very unhappy about this. They say, first of all, the Constitution addresses 2 types of power over federal elections: time, place, and manners, Congress, and the warrant. And in applying for the warrant, they relied on the election records retention provision. Okay, we can't see that yet, but I'm sure they have. The Attorney General, they write, even citing U.S. Code, this is clear, the Attorney General may make a demand in writing for the records. And they did that. And we talked about these. The NDRA, federal law says you can demand these records, and that's what they did.